Hello everyone. Today we're here to talk about pet trusts and including them in your estate plan, specifically under Florida law. So the title of my presentation is The Perfect Way to Include Your Pets in Your Estate Plan. A little about me. I'm Megan M. Kelly, operating under Megan M. Kelly, Attorney at Law, PA, in Florida. I also have clients in Colorado, where I also practice. I'm also licensed in Washington, D.C. Most of my years of practice, over 20 years, have focused on estate planning. And I love that in Florida, many of my clients choose to include their pets in their estate plan. I also help businesses, and many of my clients are small, closely held businesses, and I assist them with their business succession as well as their estate planning. So just a little background on estate planning in case you are not familiar with it. Who needs an estate plan? I think everyone does. It doesn't matter if you have a little wealth or much wealth. Everyone should have an estate plan, and the reasons vary. If you have minor children, you want to be taking care of them, and you just generally want to make sure that your stuff is going where you want it to once you pass someday, which we inevitably all will. I love that in Florida and possibly in other states, you can include your pets, our fur babies, as part of our estate plan. So that's what we're focusing on here today. But I just wanted to give a little background so that everyone is on the same page when we talk about estate plans. So these are some statistics that I found in an article by the Florida Bar. More than 62% of Americans have a pet. Of course, the most popular ones are dogs, cats, but many people have those unconventional pets as well. 90% of pet owners consider their pets to be part of their family. I'm just not sure about what the other 10% are thinking. I myself have 3 pets, and they are loved dearly. They are definitely part of our family. Okay, when we talk about estate planning, some of the documents that you may be familiar with or possibly already have are a will, a general durable power of attorney, and then there are the what I call the medical suite of documents, which might include a designation of healthcare surrogate. Different states might call that something different, like an advance directive, a living will, and a HIPAA release, and possibly a trust. So Florida law has a statute that permits us to provide for pets in our estate planning. One is the pet trust, which we will get into here in a minute. But here is an example of how you can also provide for your pets in your general durable power of attorney. So the document that I use for my clients has a specific section allowing the agent you are naming to take care and control of your pets so that they are not neglected or ignored if something happens to you. And that's just an example of the language that could be in a document like that. Many people ask me about the difference between a will and a trust. So just to kind of get that out of the way, a will direct where you want your property to go when you pass away. However, it will require a probate in order to get that done. A trust has the benefit of going around the probate process and avoiding that, and is a bit of a more streamlined process when done correctly. It does cost a little more upfront. However, you would be saving money on the other end, is how I have my clients look at it. Okay, so the pet trust. What is a pet trust? So I guess we should start by talking about what a trust is. So a trust is basically a document that would allow you to devise your estate to whom you want it to in the way that you want it to. So whether it's right away at your passing, like a will would do, or whether it stretches out over a number of years, which is appropriate in some cases and depending upon the type of estate you have. So a pet trust in Florida allows us to provide for our pets just like we would Well, sort of like we would for people, for our children, grandchildren, others. So there are some limitations, and we'll go over the specifics of how you do that. But you can create a trust that is there with certain money available for your pet and designate someone to take care of them. Okay, here's reasons to consider including your pet in your estate plan. Think about what would happen to you if, think about what would happen to your pets if something happened to you and no one knew that the pets were home alone, and that could be for an extended period of time if you were in an accident or something like that. So we need to be considering that. When you create a pet trust, you're designated someone to take care of them, and it's much more likely that the pets would be attended to quickly if something happened to you, whether an accident and you are incapacitated for a period of time or at your passing. Some things to think about that help to make sure that checks and balances in a pet trust, because we're going to be naming a caretaker for the pet, but we may want to have some checks and balances as far as how the money is used. Perhaps you want a separate person to be in charge of the money for the care of the animal. So a trust protector is one way to do that, and they oversee the person who is managing the money for the trust for the care of your pet. And then an animal care panel is another way that that can be done. So those would be used in cases where there might be more money left for the pets, or in cases where maybe there are multiple pets. Okay, here's just a little more on the basics of what the law in Florida says about the pet trust. So we select the caregiver, and that is what you see there with the picture with the cat, and the legal advocate's role in providing counsel and suggesting possible ideas and resources. So we need to think about all of that, and we'll be going over that in some more detail here. So pets have historically and under common law been considered property, and they technically still are, even though in Florida we can include them in a trust. So the pet trust is kind of a way around that, and lets us consider them more like we do during our lifetime. So here's the citation to the Florida statute. It's 736.0408, and this statute provides that a trust may be created for an animal. Now, it has to be an animal who is living at the time you create the trust. However, you can include multiple animals. So this law was created in 2002, and there have been some updates to it since then. And so today we're talking about the most current version. So the pet is the beneficiary during the pet's lifetime. So here are the specifics if you would like to go about creating a pet trust. You need to choose a caretaker, so someone you trust to take care of your pet, and possibly someone who has been involved in that process during their lifetime, someone you know and trust, and preferably who your pet knows and likes. And then you also need to choose what's called a remainder man. So this person would receive the balance of the trust assets once the pet passes away. So the trust assets would be there for the care of the pet during their lifetime, and you can create as many specifics as you want in your trust about how that should be done. And then at the end of the last pet who's included in the pet trust, when the last one passes away, then the rest of the money, if there is money left over, would go to that remainder man. So that could be a family member, that could be a friend, that could be a charity. That's really up to you. So how much money should you leave for the benefit of your pet? That really it's determined by a number of circumstances. Of course, how many pets are being included in the pet trust, the nature of their daily care, so how you are generally taking care of them now, their standard of care. Do they require veterinary care? Perhaps they have special conditions that require medications or care, so that's something to think about. Or even if you have a younger pet, that may be something they require down the road as they age. Some pets live a really long time, so we would want to include more money for the parrots, and other ones, turtles maybe. And then some have shorter lives, and so we want to consider that as well. So we really want to, I guess the goal would be to maintain them in their current standard of living. Okay, in order to make sure that the pet trust is really airtight and avoid any challenges by heirs, people who think that they should have been the beneficiaries instead of the fur babies, we really want to make sure that the pet trust is written as clearly as possible. So you want to be very specific, and this will show that you really gave a lot of thought to it and that you really meant to create this trust for your pet. Okay, this is just a note on something that the Humane Society in Naples offers. And this is who I originally prepared this presentation for. So they have some benefits where you can include your pet in the Forever Plan, and it's very helpful because then the Humane Society can take care of your pet if there's no one else to. So, for example, if you were not able to or simply did not create a pet trust, then the Humane Society would take control of your pet and they would get them into the foster care program and possibly even adopted. So this is a possibility. How do you make sure that everyone knows that this is where your pet should go? It's very important that you have your veterinarian rechip your pet so that the Humane Society is listed as the alternate emergency contact. That way, they will avoid taking your pet to the animal shelter where, if they were not collected or adopted, they could possibly be euthanized. So, this will make sure they go to the Humane Society, a no kill shelter, and that they are having a good and loving place to be. There's more information, by the way, on the Humane Society website for that. They have a ton of resources there, so check that out. Okay, so a letter of instruction is something that I recommend my clients leave, whether or not they are including their pets in their estate plan. And this is not a particularly a legal document in terms of a form, a set specified document. However, it does allow the people you're leaving behind and the people you're designating as your agents and trustees to know where you keep your assets, where you bank, or what is in your trust. All of these things that we know and sometimes nobody else knows. So it's a good place to leave a list of assets, or possibly even information about how you access those. Of course, you want to leave that in a very safeguarded place, but it's a very good idea. And this, in the pet's case, would include information about medical care for the pet and any specifics about their care, etc. Also, you could let people know how you would like your pet to be memorialized once they pass away, whether they're to be cremated or buried, or what you have in mind. So that concludes our talk about pet trust today. I hope it's been helpful. I hope you learned something, and if you'd like to know more, please reach out. Here's my contact information. Thank you so much. Go give your fur babies a hug.